Greetings and welcome back. Today I want to, in a couple of mini lectures, I think I can get freedom of religion in 2 mini lectures. As I mentioned in the last lecture, freedom of religion is really divided into two separate components. The first, and the one that the court has probably spent the most time on, is the notion of the no establishment clause. As I mentioned at the end of the last mini lecture, we use this term frequently, wall of separation between church and state, but there's no mention of this anywhere in the Constitution. Thomas Jefferson, in a letter, talks about this, but it clearly is not anywhere in the Constitution itself. The question that is at the center of the Establishment Clause is, at what point is the government promoting or potentially inhibiting religion? So I'm going to give you three controversies. The one that is the most important for constitutional reasons is the Everson case. So in your notes, it has Everson versus the Board of Education. This was a highly controversial 5-4 decision. And essentially the basic facts are pretty straightforward. They're pretty clear. The state of New Jersey passed a law allowing reimbursement by local school districts of parents sending their children using public transportation to either public or private schools. Now, Mr. Everson claimed that there was indirect aid being given to Catholic schools because 96% of the schools, the children who were going to private schools were Catholic children. But the aid was not going to the Catholic Church. The aid was not going to the Catholic school. The reimbursement program was to go directly to parents. So, for example, if you were a parent who sent your child to school using public transportation, say a bus or a subway, and let's say that the transportation cost was about 10 cents a day, which sounds about right in 1947. And let's say there are 180 school days in the year. At 10 cents a day, if you sent your child to school every day, your cost of sending your child to school would be $18. And based on this New Jersey law, the state of New Jersey would write a check to the parents for $18 to reimburse the transportation costs of sending their child to and from school. So the Supreme Court in this case did a couple of things. First, the thing to underline and put about 3 stars next to in your notes is that the Supreme Court incorporated the Establishment Clause in this particular case. Justice Black, who wrote the opinion in this case, reasoned that the law did not pay money to Catholic schools or support the Catholic Church directly in any way. Justice Black said, upon looking at the results of this law, in his opinion, he believed that this law did nothing more than assist parents of all children, both religious and public, in sending their children to school. And in this particular case, the primary purpose of the law is secular. It's getting kids to and from school. Certainly, you could make the claim that there is a slight nudge to religion in this particular case, but the Supreme Court's reasoning in this case was that the primary purpose of the law was secular, getting children to and from school, and I agree with that. I think the Supreme Court clearly made the right decision in that case. The fact that the Supreme Court incorporated or applied to the states another constitutional provision, in this case the Establishment Clause, is at the heart of this case. Now, even though this first case is, from a constitutional perspective, the most important, there clearly is no doubt that the single most publicized, controversial, Supreme Court decision regarding freedom of religion is the second case, the case of Engel versus Vitale. In this particular case, the state of New York devises a very short New York denominational prayer. The New York State Board of Regents composed this prayer after consulting with Catholic, Jewish, and Protestant religious leaders and was to be completely voluntary. So any child who did not want to say this prayer could remain silent or could leave the room while it was being said. Here is the very short New York denominational prayer that went to the Supreme Court, and it goes as follows. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. So let me repeat that. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. And as you might guess, the part of this prayer that was controversial to the parents who sued in this particular case was the acknowledging dependence on a deity or a god. In this case, remember I talked earlier about amicus or amicus briefs. These are briefs that are filed by interested parties in a particular case, and there were several of these interest group briefs that were filed on behalf of various parties. For example, the American Civil Liberties Union and the American Jewish Committee wrote amicus briefs on behalf of Engel saying that the public school prayer should be declared unconstitutional. On the other hand, 20 different state attorney generals wrote briefs saying that states should be allowed to uphold the prayer, that the prayer was legitimate, that it was traditional, that they had done this in many cases for years. And the decision by the court was very overwhelming. It was 6-1, and Justice Black, writing the opinion in this case, ruled that a New York non-denominational school prayer is an unconstitutional establishment of religion. Justice Black wrote, public school prayer is an establishment of religion, and such a union of government and religion tends to destroy government and to degrade religion. The decision was very unpopular. Lots of people, a vast majority of Americans were opposed to it. Many school districts tried to get around the Supreme Court decision. In the Schempp case, for example, I think in 1964, there was a case that reached the Supreme Court about a daily Bible reading in schools. That was struck down for the same reason. There was a case that came out of the South. I'm thinking it was Alabama. It could have been Mississippi. I don't think this one got to the Supreme Court. I think it just got to the U.S. Court of Appeals. But we had a situation where a principal decided to do a prayer over the intercom. And once again, the court said, no, that's an establishment of religion and not allowed. So the Warren Court struck down public school prayer in the Engel case, but once again, the criticism was, okay, at what point is a program establishing religion or not? And so in the third case, excuse me for that, but I was getting cotton mouth. In the Lemon versus Kurtzman case, we have a situation where the state of Pennsylvania passed an act called Act 109. The act allowed for the reimbursement of non-public religious activity. So in other words, if you had a teacher teaching in a private religious school, but was using secular textbooks, was teaching a secular subject, let's say, for example, math, then you could allow the state to help pay part of the cost of that teacher. Of course, there's a lot of questions in this case. For example, can a secular subject reinforce the religious dogma of the institution? And clearly, in math, you could do that. For example, if I were to say little Amy has 6 guardian angels to protect her from Satan. God is involved in a pitched battle at heaven's pearly gates and must recall 4 of little Amy's guardian angels. How many guardian angels are left to protect little Amy from the pits of hell? You could say, yeah, it's a math problem. 6 take away 4, yeah, it's 2. We've all done this problem. It's clearly a math problem, but I think that most of us would say that, yeah, well, Randall's reinforcing the religious dogma of the institution, and therefore, uh, in this particular case, you'd have to have government monitor these lessons for compliance, and they would discover that Randall is, in fact, reinforcing the religious dogma of the institution. So it probably is not a surprise that the Supreme Court struck down, I believe it was an 8-1 decision, struck down this Pennsylvania law. The most important point is that the Supreme Court established the so-called Lemon test. The Lemon test. And I think when I ask you on the exam, the question is going to say something like, what is the most common Supreme Court standard in Establishment Clause cases? And I believe the answers are going to be the lemon test, the lime test, the grape test, and the orange test. So remember your lemons and you'll get it right. Your textbook discusses this 3-prong test in quite a bit of detail. So I'll just recite them to you and give you just a few words to reinforce them. The first prong is actually the easiest prong for a governmental program to overcome, and that is the law must have a secular purpose. It doesn't even have to be the primary purpose, it just has to be a secular purpose. So go back to the Everson case. In the Everson case, the primary purpose of the law, in my opinion, was getting school children to and from school. Could you argue that there's a slight nudge to religion? Oh, absolutely. I think you could. But I think that that's okay. B, the law must not advance or inhibit religion. There must be a neutrality test. For example, the Supreme Court in Engel versus Vitale struck down public school prayer, but about 20 years after Engel versus Vitale, the Supreme Court ruled that Virginia could impose a minute of silence. Now, in that minute of silence, the school teacher said, during the next minute, I want you to meditate, to contemplate, or pray. I would allege that they're trying to give a nudge to religion, but I would allow the minute of silence, and the reason is that during that minute of silence, the law doesn't mandate you to say anything, to do anything, or to think anything. So even though I would argue there might be a slight nudge to religion, the law doesn't really advance or inhibit religion in any appreciable way. The last provision of the Lemon test is the law must not entangle government excessively with religion. Certainly this one is the most difficult because reasonable people are going to disagree on what that word excessively means. But go back to the example I gave. Pretend that I was in Pennsylvania and I was that teacher teaching the math lesson in order to make sure that my math lessons were indeed secular, to make sure that I was not reinforcing the religious dogma of the institution. The law would really require the government to have a monitor to make sure, in fact, that my math lessons were truly secular and not reinforcing the religious dogma of the institution. And in that respect, that Pennsylvania law would have entangled government excessively with religion. Next time, free